straight ahead on Law and Crime Daily. Celebrities plead to stop a man's execution, why his former prosecutor says he does not deserve death.
He did not mastermind this. He did not plan on this.
And a Colorado city fights a civil rights claim by the family of a man killed by police. Should a wrongful death lawsuit be dismissed in the Elijah McClain case?
Plus, a man strikes a deal in a murder case, then finds himself behind bars. How police rearrested one of the suspects in the Holly Bobo case.
Later, the alleged Kenosha shooter will be tried for murder. We break down Kyle Rittenhouse's self-defense arguments.
Law and Crime Daily covering court cases from support he has in his corner.
Yeah, Brian, Brandon Bernard's death sentence has been upheld by every court, but now some jurors who were in his trial and a former prosecutor say his life should be spared.
It was a gruesome, horrific crime. In 1999, youth ministers Todd and Stacey Bagley were kidnapped, robbed, shot, and their bodies set on fire. Brandon Bernard is scheduled to be executed December 10th for his role in the crime. He was 18 at the time.
One of the things I wanted to do was contact the Bagley's family and let them know that I felt bad and I wish I could have changed things.
Christopher Villalba, the shooter, was executed in September. Reality TV star Kim Kardashian, who's taken an interest in criminal justice reform, is supporting Bernard's bid for clemency. She tweeted that her fighting for a stay of execution does not take away from the sympathy she feels for the Bagleys. And while Brandon did participate in this crime, his role was minor compared to that of the other teens involved, 2 of whom are home from prison now. 5 jurors are also saying that Bernard should now get life without parole.
I just would not want to see Mr. Bernard, who I don't believe had any intention of killing anyone, have to die for this.
Now, one of the jurors said that he voted for death because they were told at trial that Stacey Bagley was unconscious at the time that the car was set on fire. But a defense expert is now saying that Bagley was medically dead from the gunshot wound to her head. An assistant U.S. attorney who fought to uphold that conviction on appeal now says that Brandon Bernard's life should be spared and he should get life without parole.
This idea that he provided the gun and he knew this killing was going to happen, that's not true. They got this gun because it was bigger and they thought it would be scarier. They were going to rob someone in a parking lot. That was their plan. He had no idea a killing was going to happen. He had no idea. And reading the testimony also, no one says he lit the car on fire.
Now, an investigator on Bernard's defense team says he was actually called into the crime later after the robbery had taken place because the others involved needed a ride. She says an accomplice actually told Bernard to set that car on fire once the Bagleys were dead.
Brandon is just not the same person he was when he was 18. He's 40 years old now. He was a scared and insecure teenager who, due to his home life, was looking for support and male support and male guidance, and ended up being friends with individuals who also participated in the crime.
Brandon Bernard has 2 daughters, and he's done a lot to help other people, young people, while he's been in prison on death row in Terre Haute, Indiana. Brian.
So, Angenette, we're hearing from the prosecutor and the investigator, but what does the Bagley family say about this?
Well, I actually reached out to Todd Bagley's mother, and she told me she did not want to give a statement. But after Christopher Villalba was executed back in September, she issued a statement to a TV station in Indiana, and she said that Todd and Stacey were 2 young people who were deceived and begged for their lives over several hours, and actually quoted scripture in the hope that their kidnappers would let them go. So you can tell she doesn't have any regret about these death sentences. And I should also mention, we reached out to the White House to see whether or not President Trump is actually going to consider issuing a commutation, and I have not heard back yet from the White House press office. Ryan.
With December 10th right around the corner, we'll keep eyes on that case. Thank you very much, Angenette. Terry, As I'm looking at this case, I think Angenette hit what I thought was the strongest argument, that in the previous case, they believed that the smoke inhalation killed the victim. Now they're saying it didn't. Could that fact alone be a reason to stop the death penalty here?
Well, it is a serious factor, Brian, and I think that you have to think about that as far as the death penalty is concerned. The other issue here is we should only impose the death penalty under very strict circumstances. And if, in fact, he wasn't the one to do any fatal blows, he was 18 at the time, I think we should think about life in prison without parole, which is a very harsh sentence in and of itself.
Yeah, we'll definitely keep eyes on that, because if that information can reach the court, maybe not just the president could stop this, but maybe the governor or other federal courts could pause this if that new information as to how the victim died gets to them in time. Thank you, Terry. A suspect is dead and 3 law enforcement officers are injured after the execution of a warrant ended in a shootout. The Massachusetts State Police say they were moving to arrest a suspect wanted for wounding a state trooper. Investigators tracked Andre Sterling to an apartment in the Bronx, New York. They say there was an exchange of fire. 2 U.S. Marshals were shot, an NYPD detective wounded, and the suspect shot dead. And now to Terri Austin, who has some animal news for us.
Right, Brian. Man's best friend is being credited with helping officers find a missing elderly man. An off-duty officer out hunting in Manchester, New Jersey, spotted the dog on a trail. Sergeant Charles Brooks followed Petty Paw's prints for several hundred feet. He found Petty's owner, a 78-year-old man who had been reported missing hours earlier. Police say the man had crashed his vehicle and became disoriented. Brooks was able to navigate officers to their location to safely rescue the man. And in Florida, a volunteer at Carole Baskin's Big Cat Rescue Ranch was bitten by a tiger. The organization says Candy Kosier opened a gate at a feeding time without a coordinator to help. Kimba the tiger grabbed her arm and nearly tore it off at the shoulder. Baskin is known for her role in the Netflix series Tiger King. The incident happened the same day the U.S. House passed the Big Cat Public Safety Act, which bans most big cat ownership. Brian?
And based on those 2 stories, that's why I'm a dog person and not a cat person. Thanks, Terry. Still ahead on Law and Crime Daily, a sheriff calls a plea agreement, quote, a deal with the devil. How a man talked his way out of a long prison sentence wound up back in jail. But first, we speak with the attorney for the family of Elijah McClain. Why city officials are asking a judge to We turn to Colorado, where the city of Aurora is asking a judge to dismiss a case brought by the family of Elijah McClain. Elijah McClain died last year after being placed in a chokehold by officers, then sedated by paramedics. Police say a person had made a report saying that he looked sketchy. His family filed a federal civil rights lawsuit against the city, police, and fire department. The suit claims failures to train, excessive force, racially biased policing, and inadequate medical care led to McClain's death. Police body cam video captured when paramedics administered 500 milligrams of ketamine to sedate him. Joining me now is Mari Newman, an attorney who represents the McClain family. Mari, thanks for joining us.
Thank you for having me.
Of course. Mari, in a motion filed by the attorneys for the fire rescue employees, they claim the ketamine was not an overdose. What's your response to that claim?
Well, from a legal standpoint, they shouldn't have been administering any ketamine whatsoever, because Elijah McClain was not suffering from any kind of a medical problem that required medical treatment. He was an absolutely innocent young man just walking home from the corner store when he was stopped by police, grabbed, thrown to the ground. They did 2 carotid chokeholds, administered various kinds of other types of excessive force against him, and then ultimately these medics gave him a massive dose of ketamine. Not 1 drop of ketamine was medically required, and certainly not a 500 milligram dose for a guy that was about 140 pounds.
Yeah, that was one of the major things that caught my eye when the story first came out. Totally gutted me and broke my heart. They talked about the size of Elijah McClain compared to the amount of ketamine put in his body. Can you kind of talk to us about that?
Sure. Well, so ketamine is a drug that has been used for what is called excited delirium. That's a medical condition, and I'm using air quotes as I say that, because it's actually not recognized by many different organizations. The American Medical Association doesn't even recognize it. But what you hear about is these circumstances when law enforcement kills somebody, and then later they try to justify it by saying that that person was suffering from so-called excited delirium. But in any event, Elijah McClain wasn't exhibiting any of the symptoms that are associated with it. He did not have supernatural strength, as you can see from the video. He is completely restrained under a pile of law enforcement officers. By the testimony of the officers, about 700 pounds worth of cops were on top of this 140-pound man who was begging for his life and saying that he couldn't breathe. So he certainly didn't exhibit that. He was responding appropriately. He was identifying himself. He was saying his name, that he was trying to go home, that he hadn't done anything wrong, that he didn't have a weapon. And they still administered this drug, which was medically totally inappropriate. And that was a constitutional violation of his right to bodily integrity. We cannot legally be given medication against our will. And that's what happened here.
Yeah, I tend to agree with you, Mari. I don't practice in Colorado, I practice in Brooklyn, but even in Brooklyn, what an officer did to Elijah McClain, you just can't do that. It doesn't make sense to me from a state or federal background. Mari, thank you so much for joining us today. I wish you the best of luck in your claim going forward.
Thank you so much for having me, and I'm happy to come back anytime.
I will hold you to that. Coming up on Law and Crime Daily, Kenosha shooting suspect Kyle Rittenhouse appears remotely for court. What prosecutors and his defense are saying. Plus, police nab a man convicted in a murder case just months after being released from prison. That case and more when we return. The man released from prison after admitting to his role in the killing of a young Tennessee woman nearly 10 years ago is back behind bars. Jason Autry testified that 2 other men killed Holly Bobo in the spring of 2011. For his testimony, Autry received an 8-year sentence in a plea deal the local sheriff described as a deal with the devil. Autry was rearrested after a deputy spotted him in a field with a gun. The deputy reportedly found meth and ammunition on him. Holly Bobo disappeared from her family home in 2011. Hunters discovered some of her remains 3 years later. John Dylan Adams pled guilty, and co-defendant Jason Autry testified against Zach Adams at trial.
What are your expectations? You know what I mean by that? For testifying here today. What do you think is going to happen?
I'm hoping for leniency. He asked me would I help him bury the body. And I said, yeah. I said, I will. I brought the upper torso to the end of the tailgate where he grabbed the legs, and I set the head, the upper end, on the riprap pile. And I told him, I said, this is still alive. Out of the floorboard of the pickup, he pulls a pistol. I looked around, and I told him that there was nothing coming close as clear, something to that effect. And at that time, boom, the gun sounded, the gun went off. And it sounded like boom, boom, boom. Underneath that bridge, it was just one shot, but it echoed underneath that bridge all the way down that damn river bottom.
Terry, police say they believe Autry was kind of getting high on his own supply when they found him. And with the past conviction, he's now facing up to 20 years behind bars. How is this previous conviction going to affect this new case?
Well, you know, Brian, we have to think about whether or not it's even going to come into evidence. So the judge is going to have to consider, why is it being introduced? It can't be used for motive here because they're 2 totally unrelated crimes. And actually, it can't really be used for anything else because I think any other argument is going to be, you know, a failure because the credibility of the witnesses really has nothing to do with this particular crime. So I think it's not even going to get into evidence, if you ask me. And as far as sentencing is concerned, I think the prior conviction, this is a felony conviction, I think that will affect sentencing, and I think he will get a higher sentence as far as that's concerned.
Now, of course, the family had to agree to that plea deal. What do you think their thoughts are now that he's rearrested?
Yeah, I think they're probably thinking that that plea deal is not a good idea, considering the fact that he's out there, that he's got these other issues going on. You know, he may have weapons and drugs, et cetera. He could commit another crime. So they're probably thinking he should have stayed behind bars.
All right, thank you for that, Terry. When we come back, Kyle Rittenhouse is bound for trial. The accused Kenosha shooter motion to dismiss charges was denied. How the case progresses next. The Kenosha shooting suspect is bound for trial after a judge ruled there was probable cause he committed a crime. Kyle Rittenhouse is accused of fatally shooting 2 people and wounding a third. During protests in August, Rittenhouse was released from jail on a $2 million bond. His defense was denied their motion and to dismiss 2 of the 6 charges against him. The lead investigator described the shootings at the probable cause hearing.
There was a call at 6226 Sheridan Road, which is a car source business, where shots were fired. Investigation later determined that Joseph Rosenbaum was shot in that parking lot and later determined to be deceased. Then Kyle Rittenhouse was the shooter in that incident. He then fled that scene. As he was running northbound, there was a crowd chasing after him. He ends up stumbling in the roadway after being struck in the head. When he's on the ground, a subject attempts to kick him in the head. He then fired 2 rounds in the air towards that subject, missing. Another subject approached him with a skateboard, and another shot was fired. That subject is identified as Anthony Huber. That gunshot subsequently killed him. Another subject approached Kyle, identified as Gage Grosskreutz. They had kind of a moment, at which point Kyle fired 1 time, striking him in the right bicep. Kyle's then able to get up and get away from that scene.
On cross, the defense asked the detective about victim Joseph Rosenbaum wearing a face mask at the time of the shooting.
It's a crime in Wisconsin to commit a crime while masked, correct?
Your Honor, I objected to relevance of this question.
It goes to the events in question. The state is trying to put forth a one-sided, stilted view of what happened, protecting someone who doesn't deserve protection of the state. He's a masked robber.
Okay, this is preliminary hearing. I'm going to sustain the objection, and for purposes of preliminary hearing, that's outside the scope. It's not relevant for these purposes. Mr. Richard.
Mr. Rosenbaum is not wearing a shirt in Exhibit 3, correct?
Not wearing it traditionally.
He's wearing it around his face, correct?
Correct.
The defense continued to assert a self-defense theory while cross-examining the lead detective.
Individuals in this video at approximately 9 o'clock, 12 o'clock, and 3 o'clock, which are approaching my client, and he points the firearm at them but does not shoot, correct?
Yes, sir.
And he gets up and he goes to turn himself into law enforcement with his hands up, correct?
Correct.
Did you ever see Kyle act inappropriate towards somebody who was not threatening him with a firearm?
Objection, relevance.
Again, I'm going to
Relevant.
sustain.
Government just doesn't want to hear the truth.
Mr. Richards, here's the key. You have an opportunity at trial, but we're here at preliminary hearing. I understand perhaps you're frustrated, but perhaps we continue the examination.
In the video, before my client is knocked to the ground by the strike to the head, you hear numerous individuals yelling, "Kill him, get him, cranium him," correct?
Correct.
So, Terry, I get that this figure, Kyle Rittenhouse, is very polarizing, but the one thing that disgusts me a little is poor defense attorneys. It's like a poker game and he's showing his entire hand. These are trial arguments, not probable cause hearing arguments. Am I wrong here? Or is he messing up left, right, and center?
Oh, you're 100% right, Brian, and even the judge agrees with you. The judge actually said, you know, this is just a preliminary hearing. This is not the trial. I know you might be frustrated, but this is not the time to ask those types of questions and to present that type of evidence. So you do risk tipping your hand at trial if you do all of this information at the preliminary stage. So I agree with you. On the other hand, I will say, I think everybody kind of knew that the defense was going to be self-defense, but, you know, don't show your entire hand at the preliminary hearing.
Yeah, we all know it's self-defense, but what details? The fact that the person was wearing a shirt on his head and you're going to call him a robber, that's something you spring on the prosecutors. Do you think he has any tricks up his sleeve left for the trial, or have the prosecutors maybe figured it all out by now?
Yeah, I don't think he has much left because he is doing this sort of detailed questioning that will let the prosecution know what direction the defense is heading in. So I think for him to do this when, as you said, you know, Brian, the standard is a very low bar for a probable cause hearing. There was no reason for him to ask these extended questions. So I do think that it was a mistake and that maybe he was, you know, showboating.
Yeah, this is a place I think you've got to lose the battle but win the war. Thank you very much for joining us as always, Terri. And thanks for you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.